I would like to introduce the League of Women Voters San Diego President, Kim Knox.
Thank you for joining us for this important topic. Our next event, teaching about diversity and the controversy over critical race theory, will be on Wednesday, February 9 at 5:30 p.m. on Zoom. The San Diego League is an all-volunteer organization, and I'd like to thank those attendees who made a donation when they registered for this event. If you'd like to donate after the event today, we would be very grateful for it, and I'll put a link in the chat. Now, let's see, I don't see any candidates or elected officials in the chat, so I'd like to introduce Jane Andrews.
Thank you, Kim. Good afternoon. I am Jane Andrews. I'm the events chair for the League of Women Voters of San Diego. We are delighted to have two eminent legal experts today to talk with us about the Supreme Court and controversial cases. The Supreme Court has been in the news a lot recently, and how could we have guessed that today would be the day that Justice Breyer's retirement became known? So they will speak to us until about 3 o'clock, and then we will have a question and answer period, which Kim Knox and I will moderate. Please put questions in the question and answer section, which you'll find at the bottom of your screen, not in the chat. So our first speaker is Glenn Smith, who has been a professor at California Western School of Law since 1984, where he teaches constitutional law, including a seminar on current issues in constitutional law. He is an admired speaker on the topic of the Supreme Court and has spoken at the Osher program at UCSD. Our second speaker is Marjorie Cohn. She is a former criminal defense attorney, professor emerita at Thomas Jefferson School of Law, where she taught from 1991 to 2016, and also former president of the National Lawyers Guild. She is on the advisory board of the American Constitution Society here in San Diego. She is also a legal and political analyst who writes a regular column for Truth Out, a nonprofit news organization dedicated to independent reporting and commentary on a wide variety of social issues. And I do encourage you to look at her interesting website at marjoriecohn.com. So I'd like to turn this over to Glenn.
Thank you so much, Jane and Kim and everyone who's in the leadership of this great organization. As your video was scrolling across, I was reminded how great it is to be speaking to a group whose mission is in a bipartisan and a thoughtful way to empower voters and empower democracy. It's great to be associated with that. It's especially also to be great. It's also great to be associated with Marjorie Cohn, who I've followed from afar for a long time and really admire, but it's fun to be participating with her on this panel. I want to say I'm going to claim personal credit for Justice Breyer's retirement. When we were coordinating a couple of days ago and we were exchanging phone numbers, just in case any last minute developments happened of relevance, I joked and said, oh yeah, like Breyer's retirement. And it turned out to be true. So I, like carrying an umbrella and causing it to rain, I'm going to take credit for that. In all seriousness, I really do appreciate being with you today. And I've prepared, was starting out to just show a few slides from some PowerPoints or resource slides that I've done in the past. But the more I worked on this, the more I thought, you know, this stuff's kind of complicated and it might be helpful to have my subjects especially covered this way. I'll mention, hopefully I'm now sharing in a way, not only the title, but my address. If anyone would like this PowerPoint at no extra charge, feel free to email me, or if you have anything you're interested in or any kind of conversation you want to have after this. I'm looking forward to a great Q&A from the members. And if there's something beyond that, please consider me as a current resource. As I've said, my talk is about, despite the controversial and ideology fraught cases, because there are a number of them, and certainly Marjorie's going to cover several as well, the question for me this term is the court going to protect its legitimacy and reputation in the way that it resolves some of these high profile issues? Or is it going to further add to what we've noted as some public cynicism about the court and assumption that the court is nothing more than politicians who wear black robes? And I've spent my life trying to convince people that the view that the court is completely about politics and all that is wrong and naive and one-dimensional, but so is the view that the court is completely above politics. It's like most things in life, a complicated mixture of dynamics that ebb and flow. And I think in part, ultimately, we the people have some role to play, although maybe not directly, in how that goes. Anyway, I was, whoops, come on, let's share this thing. Okay. I was asked to say a little bit from my perspective as just following the court's term every year from a general sense. I teach a Supreme Court simulation class, both in my law school and at UCSD. So I always like to, when I talk to audiences, those and others, I always like to remind people that in terms of the typical court term, first of all, the vast majority of cases come from federal courts these days. And as much as I love, and I know Marjorie loves and others love talking about the real hot button controversial constitutional cases where the court splits 5-4 and writes hundreds of pages of opinions, that's really not the majority of the court's work. Majority of the work of the docket doesn't involve constitutional issues. It involves questions somewhat more humdrum, but often equally important cases, questions about interpreting statutes. How does Congress's intent apply in this situation? What does an administrative regulation mean? Was an administrative agency acting arbitrarily and capriciously? How do various court rules increase the access that citizens and underrepresented people have to the courts, or decrease it? And that's a majority of the court's business. People often, and I'm as guilty of this, if not more than all of you, focus on those few 5-4 controversial decisions, especially the ones that split ideologically. But I like to remind groups that often a large percentage of the court's opinions are more consensual than 5-4, or even than 6-3. And here's some data from the last term that shows that, 2/3 of the court's opinions were 9-0, 8-1, 7-2. Now, obviously, those are not the most controversial and important decisions, but it's interesting to remind ourselves in an era where we see so much polarization, both on the Supreme Court and elsewhere, especially in our other branches of government, that the court does render a lot of decisions that don't fit into that frame. Even though it's clear that levels of agreement among justices show ideological clumping or ideological, people of fellow travelers, I like to also point out that even in the lowest levels of agreement, so this is from last year again, Thomas and Sotomayor only agreed 55% of the time. Gorsuch and Sotomayor only agreed 93% of the time, whereas Kavanaugh and Roberts agreed 94% of the time. Still, in a majority of the cases, again, not always certainly not the high profile cases, but in a majority of cases, justices across the ideological spectrum agree. In the interest of time, given there's other fish to fry, I'm gonna not administer my true false questions about the Ninth Circuit, but get around to those perhaps. So what do I think are the 4 highest profile cases on the court's docket? That is those cases that not only will make a big difference to lots of people in the country, and will have political saliency, but I really think they're going to have the biggest impact on the court's legitimacy. The first case is a case that Professor Cohn's going to discuss, which is the series of the Mississippi abortion regulation challenge. And I believe she's going to talk about the related Texas SB 8 law, but I'll leave that to her. The main case I'm going to discuss is the New York gun regulation challenge, which has been argued. So has the Mississippi case. But I think that the court has a range of options for deciding this, which it will will affect its legitimacy a lot. Will it be perceived to have been trying to evolve the law and do it in an appropriate step? And will there be some consensus, or will it be a strictly ideological decision that will further undermine or further deepen concerns about the court's legitimacy? There likely are going to be one or two forthcoming challenges to President Biden's vax or test mandate for federal employees and maybe also for federal contractors. Going to discuss a little bit about that. Not going to talk about, but wanted to flag for your interest, a case the court just accepted a couple days ago. I'm sure you saw it. Challenges to Harvard's and the University of North Carolina's affirmative action programs and admissions, which again are very likely to generate lots of controversy. Just want to mention, I don't want to go into these in the interest of time, but beyond that, there are a number of important cases that relate to the death penalty, that relate to free speech, equal protection, including different treatment of Puerto Rico under a social service program, and two very interesting cases involving religious freedom and the establishment of religion. There are also some significant cases that relate to government accountability, the extent to which the federal government can be held accountable to people, including challenging clandestine CIA activities or intelligence surveillance and alleged abuses by federal immigration and drug enforcement officers. So again, I know that was too fast to focus on any one of those, but I'm happy to talk about those in the Q&A. And I just wanted to give you a sense that although we're going to zero down and talk about I'm going to talk about at least two high-profile areas, it doesn't mean there's not more on the horizon. The broader court legitimacy context for this term, and especially for the big controversial cases, is that, as you may have read, I mean, let's face it, the court always needs to be concerned about the perception that it is the one institution in our federal government that can rise to some extent above politics. That's important for the fact that the court does not have a lot of enforcement power on its own and needs at least the grudging acquiescence of the public and its officials. I'm reminded of one of my favorite quotes from Blanche Dubois in A Streetcar Named Desire. She says she depends on the kindness of strangers. I don't know that the court needs the kindness of the public and its officials, but it at least needs grudging acquiescence. And therefore, there have been some recent concerns that for the first time, for example, since Gallup has been asking about approval of the court's overall approval rate dipped below 40%. Some interesting poll data came up from the Annenberg Public Policy Center that has been asking people for years questions about, would they favor abolishing the court if it makes a lot of rulings that most Americans disagreed with? And should the court's power be restricted? And a substantial minority of people, especially political moderates, endorse those ideas in the polls. And that apparently got to the attention of a trio of conservative judges, Justice Breyer, whose retirement was leaked or announced today. It wasn't announced, but was leaked today. Also does a lot of discussing about the court's legitimacy and is very concerned, wrote a recent book about the politicization of the court. But Justices Barrett, Alito, and Thomas all took to the rostrum to push back on the idea that they were just engaging in partisan discussions. But the fact that they have to feel the need to do that, I think, suggests that that concern has reached a higher level. You may also know that there's been a recent report by a bipartisan commission appointed by President Biden to look into structural reforms, including some major reforms in the court packing or expanding the number of justices on the court, coming up with 18-year terms, concerns about the, quote, shadow docket of the court, or the fact that, as was much in the news, the court's recusal rules, the rules for example, for Justice Thomas to recuse himself from cases where seemingly his wife had strong opinions and involvement, that those are residing in the Supreme Court justice's own independent judgment rather than as part of something that we seek to regulate by judicial rules, etc. That is all in the mix here. And in my sense, it's brooding over, or it's a cloud that the court needs to deal with. And so I think it's important to see if the court is going to handle big cases. The big case so far that I want to talk about that's on the docket is a case called New York Rifle and Pistol Association versus Bruin. It's a case that's, again, already been argued. And the issue is whether the state of New York's denial of applications for concealed carry licenses for self-defense violate the Second Amendment. And again, I have no illusion, even when I put these slides as part of this PowerPoint, that I would get through all of it, but it's there in case it's of any value to anyone who would like to request this. I will not feel personally offended if you don't, but just FYI, if it would be helpful to you, I'm happy to do it. This is the way I usually speak to groups, give you TMI and not cover it all and see where we get. I did write an article in May on the Los Angeles Daily Journal about this, talking about the quote seismic shifts that this case should cause. Basically, the background of this case is that California, like New York and a half dozen other states, does not allow residents to carry a concealed handgun. Certainly, they forbid open carry, but they don't allow concealed handgun carrying unless the applicant establishes a quote special need or an unusual need for self-protection. I mean, the classic example would be that the person's being stalked by someone who's under a court order not to come near them, or that they own a jewelry store in a high crime area or something like that. Just asserting a general right to self-defense is not sufficient in these jurisdictions, including California, to get a permit. And that's been consistently upheld by lower courts. The very brief background on Second Amendment rights is that until 2008, in a case called District of Columbia versus Heller, everybody thought that, not everybody thought, but the conventional wisdom was that Second Amendment rights only applied to the federal government and DC, and that they only really applied to the right to own a gun in context of participation in a quote well-regulated militia or something like that. But by 5-4, in an opinion led by then Justice Scalia, the Heller court held that the central component of the Second Amendment was an individual right to self-defense, going back to the frontier days and et cetera. Everyone had a right to self-defense, regardless of militia participation. They invalidated a very extreme District of Columbia law that basically banned handgun possession in the home and required that any other guns in the home be disassembled and locked, while acknowledging that there could be legitimate regulation of certain kind of guns. And there was a fair amount, there was a perception, of course, that this sort of shifted the tectonic plates of Second Amendment law. But the court didn't provide a lot of clarity, but not to worry, they would provide it in later cases. Well, they had a case in 2010, but what that established is that this right also applied to state and local governments, which of course means that every California or San Diego law that relates to gun control is now subject to an argument that it violates the Second Amendment. What the court did, however, is stay out of a number of challenges that bubbled in the lower court. And it repeatedly declined review. Finally, in 2020, we have the New York gun regulation case. And like most Supreme Court cases, there's a range of possible decisions. So the court actually rewrote the issue to narrow it and give themselves the opportunity to invalidate New York's law. I think most of us think New York's law will be invalidated. The question is, kind of ironic to have this conversation with a lot of police sirens in the background, but it's possible the court can decide this very narrowly and invalidate the New York law because of special concerns about the subjectivity or the discretion that New York officials had and the arguable abuses that occurred there. That would give us a very narrow holding that established gun rights, but in New York, with New York and any other kind of laws that have that history. More broadly, the court could invalidate all proper cause concealed weapon permit schemes, including ours in California, so that California officials in San Diego and Los Angeles and San Francisco would have to bear the burden of showing that someone should not carry a concealed weapon rather than the person having to show that they have a special need for it, which would, from my perspective, be quite troubling living in San Diego. But nevertheless, they could invalidate more broadly all concealed weapon permit schemes altogether, even states that don't require that the burden be on the applicant. They could establish even more broadly a broad right to open carry for guns. They could make the validity of all gun restricting laws dependent upon analogies to history and tradition, which would leave lots of uncertainties. Or they could establish that strict scrutiny, which is Marjorie especially knows, is a real tool that makes it very hard for government to survive scrutiny because government has to show a compelling interest, and that the law is the narrowest law possible to further that compelling interest. If San Diego's and California's and the gun control laws in the rest of the country were subject to that kind of a ruling, it would be a real game changer for gun control laws generally. And that's where I think the legitimacy issue comes up. The court is perceived as using this case, and it's a majority on the court using, and I would argue abusing its power to establish rights very, very broadly beyond the narrow confines of this case. I think it'll question its legitimacy. The second topic I'd like to at least put up on the mat and then talk about more if people have questions during the Q&A is, I'm sure as most everybody knows, or everybody knows, the court very recently in a split decision allowed challenges to the Biden administration policy that required vaccinations or regular testing for any company that had 100 or more employees, so large employers. That was the basic, although it was allegedly a preliminary ruling, the court basically made it clear that they didn't think that that administration plan had sufficient statutory authority. It was illegal. So although they theoretically sent it back to the lower courts, they sent it back with a very strong message. On the other hand, they greenlighted the requirement that providers who get Medicare and Medicaid benefits, who serve those patients, take strong measures to make sure that their employees are back. So it's a split decision, requiring vaccination for employees who serve Medicare and Medicaid people allowed, requiring vaccinations for large employers, pretty much deep sixed. There are two other cases though that I think are lurking and will likely come to the court. And if they come to the court, they will likely come to the court on an expedited time frame, just like the two recent decisions of the court did. One involves a federal contractor mandate. Basically, all contractors and subcontractors who perform work on certain federal contracts have to ensure that their employees are fully vaccinated, unless they're legally entitled to an accommodation. That's the description of the law by the Georgia district judge, who issued a nationwide injunction banning that. So that is not going into effect and is going up through the higher courts, perhaps to the Supreme Court. Most recently, a few days ago, a federal judge in Texas, district judge, issued a nationwide injunction barring implementation of a different executive order that required all federal employees to be vaccinated or to obtain a religious or medical exemption. Again, these are just lower court cases. They're preliminary decisions, not on the ultimate merits, but on whether this thing should be shut down while the court has more time to think about it. But as we've seen from the Supreme Court's rulings, which I've described in this slide, these quote preliminary rulings, the court seems to be using it to signal very strongly whether it supports or doesn't support vax requirements. Why these, in case you didn't focus on it, the previous slide points out that adding a special ideological dimension to this is that both of the district judges who issued these nationwide injunctions, stopping the federal contractor mandate or the employee mandate, were appointees of President Trump. So I always like it when, like with the last administration's laws and all that, you get a bipartisan, like the League of Women Voters, you get bipartisan judges in terms of who appoints them, either striking down the travel ban or upholding this or whatever, but we don't have that pattern, at least so far with this. Seems to be a much more ideological pattern that is associated with who did the appointing. Just to talk about this case as possible dynamics, assuming this goes to the court, I realize I'm being a little speculative here. You can see that the swing voters in this case, people that upheld the Medicare and Medicaid mandate, but did not uphold the larger employer mandate, are Roberts and Kavanaugh. It would seem that whether either of these two additional, the contractor requirement or the employee requirement, survive or not is going to depend on how those two justices judge the situation. And I give some examples here that I don't have time to go over, but basically the major issues for these swing voters, these on the court, these justices are going to be, okay, is the authority exercised by the executive department and the president here comfortably within or outside of both the statutes Congress has written, and are they typical things the agency has done before? One of the reasons why a majority of 6 justices, including Kavanaugh and Roberts, struck down the OSHA rule for large employers was they said, OSHA's never done anything like this before. It was unprecedented. And so that's going to be part of it. But obviously, it's also going to reflect the justice's assessment of how big are the costs imposed on the regulated parties? Did they have fair notice? And how legitimate and important is the exercise of presidential power? I have to say, before I read the opinion, I was kind of surprised, especially by the Texas judge, invalidating the president's control over federal employees. It would seem that as head of the executive department, the president has broadest control over his employees. And yet there are substantial arguments. In fact, the Texas judge draws an analogy, a direct analogy to the recent Supreme Court decisions and says, just as you said, there's a difference between workplace dangers and general dangers in the society. Under that theory, President Biden doesn't have the authority to generically impose vaccine requirements on employees. So unless I misjudge this, or there's a lot of appellate courts shutting this down, but I think it's still going to be appealed to the Supreme Court, unless the Supreme Court is tired of being involved in these vaccine mandate cases and is returning to what I think would be a sounder policy of deferring more to the officials that are trying to deal with this, but that's just my opinion and people disagree. I think these are going to be on the horizon in the short term. Speaking of the short term, I want to stop talking and give our other panelists some substantial time. And I just want to say I really appreciate your attending. And I will leave you with one of my favorite quotes. I don't even know if Garrison Keillor's Writer's Almanac is still on anymore. Great program that saluted poetry, but his closing line was, "Be well, do good work, and stay in touch." And I hope that's true for all of you. And I appreciate the time to spend with you today. I look forward to your questions. Thank you.
Thank you, Glenn, so much for such an informative discussion. Marjorie, over to you.
Okay, well, I am going to talk about the abortion cases and voting rights, which do break down along ideological lines, unfortunately. In 1973, in Roe versus Wade, the Supreme Court ruled that abortion is a fundamental right for a woman's life and future, and states cannot ban abortion until after a fetus is viable, which is generally around 23 weeks of pregnancy. And the Supreme Court reaffirmed the essential holding of Roe in Planned Parenthood versus Casey in 1992, and said that states could only enact restrictions on abortion that do not impose an undue burden on the right to a pre-viability abortion. Now, both Roe and Casey are grounded in the right to abortion is grounded in the liberty section of the Due Process Clause of the 14th Amendment. On December 1st, the Supreme Court heard oral arguments in the Mississippi case of Dobbs versus Jackson Women's Health Organization. And during that argument, the justices, and I use justices in quotes because when I write, I never call them justices, I call them members of the court because unfortunately, in my opinion, most of them are not doing justice these days, in my opinion. But they confirmed what progressives have feared since Donald Trump added 3 radical right-wingers to the court. And that is that the 6 conservatives on the court are poised to gut the fundamental right to abortion. For the first time in its history, the Supreme Court is poised to retract a fundamental right. Mississippi passed the Gestational Age Act, which outlaws nearly all abortions after 15 weeks of pregnancy, well before viability, clear violation of Roe versus Wade. The law contains exceptions for medical emergencies and cases of severe fetal abnormality, but there is no exception for rape or incest. A federal district court and the Court of Appeals blocked Mississippi from enforcing the law because it violates standing constitutional law, which is Roe versus Wade. Kavanaugh and you'll hear where the justices look like they're coming down when I tell you what each one of them said. Now, you can't always predict exactly how a member of the court is going to vote from what they say at oral argument, but I think that we have a pretty good indication from what they said. Kavanaugh said that the court shouldn't pick sides, but should remain scrupulously neutral on the question of abortion, neither pro-choice nor pro-life. And why shouldn't we leave the decision to Congress, the state legislatures, or the state Supreme Courts? Kavanaugh, who during his confirmation hearing had assured the senators that Roe versus Wade had been reaffirmed many times in 45 years, and Casey had been reaffirmed in its precedent on precedent, he justified his apparent intent to overrule Roe versus Wade by listing cases in which the Supreme Court had overruled prior decisions. But as Sotomayor pointed out, most of those cases resulted in the court recognizing and overturning state control over issues that we said belong to individuals, such as racial segregation, voting rights, criminal legal rights, and the rights of same-sex couples. Amy Coney Barrett callously said, well, outlawing abortion wouldn't hurt women because they could simply carry the pregnancy to term and then put the baby up for adoption. And she cited so-called safe haven laws that represented this particular position. But as the lawyer for the clinic, Mississippi clinic, wrote or said during oral argument, it is 75 times more dangerous to give birth in Mississippi than it is to have a pre-viability abortion. Neil Gorsuch questioned the workability of this undue burden standard of Casey, and the lawyer for the government replied that the undue burden standard without viability, in other words, without Roe versus Wade's limit of 23 weeks, is tantamount to overruling Roe and Casey because viability is central to those cases. And states could enact laws like the Mississippi law, 15 weeks. After 15 weeks, abortion would be illegal. And the Texas case, which I'm going to talk about, which outlaws abortions after 6 weeks. Now, Chief Justice John Roberts, who is a right-winger, but also has another very strong interest, and that is preserving the legitimacy of his court, the Roberts Court, tried to couch his position as pro-choice. He said, well, women can choose to have an abortion until 15 weeks of pregnancy. But as the Solicitor General, who was defending the right to abortion and opposing the Mississippi law, pointed out, without viability, there'll be no stopping point. States could outlaw abortion after 3 weeks, 5 weeks, 6 weeks. Justice Sotomayor noted that 15 justices from differing political backgrounds have affirmed the Roe versus Wade viability cutoff since 1992. And she asked the lawyer for the state of Mississippi, how is your interest anything but a religious view, referring to the debate over when life begins? Samuel Alito didn't pull any punches. He said the fetus has an interest in having life, and that is clearly where he's coming down. And Clarence Thomas was just interested in expanding criminal liability for women for fetal endangerment before the period of viability. Stephen Breyer, who we hear now is going to retire at the end of this term, the end of June, quoted from Casey, and he said, to overrule under fire in the absence of the most compelling reason to re-examine a watershed decision would subvert the court's legitimacy beyond any serious question. And in a much quoted statement from Justice Sotomayor, she said, will this institution survive the stench this creates in the public perception that the Constitution and its reading are just political acts? Now, on September 1st, the right-wingers signaled their intention to gut Roe versus Casey by allowing Texas's Senate Bill 8, the so-called fetal heartbeat law, which outlaws abortion after 6 weeks of pregnancy, to go into effect with no briefing, no oral argument, and no consideration by lower courts. In other words, even though on its face, outlawing abortion after 6 weeks violates standing precedent of the Supreme Court, Roe versus Wade and Planned Parenthood versus Casey, the right-wingers on the Supreme Court allowed this to go into law, which has resulted in the majority of women seeking abortions in Texas to be denied abortions because SB 8, this heartbeat law, remains in effect. Who is going to suffer most? Poor people, people of color who cannot afford to travel to a state where abortion is legal. They will be most strongly affected, because if Roe versus Wade is overturned, and I predict that it will be at the end of June of this year, then the states will decide whether or not they should outlaw abortion. And I'm at this point very proud, and for a number of other reasons as well, to live in California, because California is reportedly becoming a sanctuary state, which will raise money to pay for poor women, women who cannot afford to travel from other states where abortion is outlawed, if and when Roe is overturned, and pay for their transportation, pay for their medical expenses, pay for their accommodations and their food. So I think that's a real feather in California's cap. Now, SB 8, which is this Texas heartbeat law, outlaws all abortions after cardiac activity can be detected, generally around 6 weeks before most women even know that they're pregnant. It contains no exception for rape or incest. What SB 8 does, it was drafted in a very Machiavellian way, because generally, if there is a state law and it is challenged. The way to challenge it is to sue the state officials. But what SB 8 did, the way it was written, is to insulate it from being challenged on constitutional grounds, because what SB 8 does is to basically deputize everyone in the world to sue abortion providers and anyone who aids and abets these abortion providers. And that includes counselors, family members, clergy, Uber drivers. Plaintiffs who win get $10,000, and the defendants, the abortion providers, have to pay their attorney's fees. On September 1st, in Whole Woman's Health, 5 right-wing members of the Supreme Court refused to block SB 8 from taking effect. And on December 10th, the Supreme Court ruled that the provider's constitutional challenge can go forward, but only against a very limited number of people, people who medical licensing officials. They also left SB 8 in place. These are all preliminary. The Supreme Court has not ruled on the merits, the constitutional merits of SB 8 yet. They are just talking about whether the lawsuit challenging it can go ahead. On January the 20th, the Supreme Court rejected abortion providers' request to order a federal appeals court to send their challenge back down to a lower court judge. Again, keeping SB 8 in effect, denying women in Texas the right to an abortion, which is guaranteed under Roe versus Wade and Casey. It was a one-sentence decision on January 20th, just turned down the provider's request. And in the main dissent, Sotomayor called this a transparent effort to stave off review of the merits of the provider's challenges. And she quoted one of the judges who heard oral argument in the case, who suggested that the Court of Appeals could, quote, just sit on this until the end of June, unquote, until the Supreme Court overrules the Mississippi law, overrules Roe v. Wade in the Mississippi case. And by the way, the Supreme Court is squarely being asked to overrule Roe versus Wade in the Dobbs case, in the Mississippi case, which they will decide by the end of June. Now, I want to move now to the voting rights cases, and that has been in the news, as we know. Just a minute, I am sorry, I seem to have misplaced. Here we go. Okay. All right. Now, Reverend Martin Luther King Jr. said, and I quote, "The denial of this sacred right to vote is a tragic betrayal of the highest mandates of our democratic tradition." He said that in 1957. And on January 18th, the day after we celebrated King's birthday, and 1 year after a mob of right-wing Trump supporters attacked the Capitol in an attempt to overturn the results of a free and fair election, the Senate began debating voting rights legislation aimed at stopping voter suppression. But the legislation was doomed to failure. The right to vote is preservative of all rights, the Supreme Court said in 1886 in the case of Yickwo versus Hopkins. The Constitution mentions the right to vote in 5 different places: the 14th, 15th, 19th, 24th, and 26th Amendments. And each one of those empowers Congress to enact appropriate legislation to enforce voting rights. And yet, right-wingers, enabled by congressional Republicans and reactionary members of the Supreme Court, are mounting a full court press to prevent marginalized groups from voting. During Reconstruction after the Civil War, the 15th Amendment was added to the Constitution, and it prohibits the federal government and the states from denying or abridging the right to vote on account of race, color, or previous condition of servitude. As a result of the civil rights movement, Congress passed the landmark Voting Rights Act in 1965 to enforce the 15th Amendment. The Voting Rights Act forbids voting changes if their purpose or effect, they don't have to be intentional, but their purpose or effect is to diminish the ability of citizens to vote on account of race, color, or language minority status. Now, Congress authorized the Voting Rights Act, reauthorized it 4 times with strong bipartisan majorities. Each reauthorization was signed by a Republican president, and the Roberts Court has now usurped the power of Congress and eviscerated the Voting Rights Act. In 2013, in the case of Shelby County, Alabama versus Holder, a 5-4 right-wing majority struck down the provision of the Voting Rights Act that required that before jurisdictions with a history of discrimination could enact a new voting rule, they had to get pre-clearance from the Department of Justice or a 3-judge panel from the DC Circuit Court of Appeals. John Roberts wrote for the majority on behalf of himself, Thomas, Alito, Scalia, and Kennedy. And of course, Scalia and Kennedy are no longer on the court. The majority in Shelby took a states' rights approach, which will allow states to enact racist voting laws. They looked only to the end of discriminatory voting tests and the lack of disparity between whites and non-whites in voter registration and turnout since the enactment of the Voter Rights Act. And then the court concluded that, okay, we're fine, everything's great. And they struck down basically the guts of sections 4 and 5 of the Voting Rights Act, no longer requiring pre-clearance before states with a history of racial discrimination can change their laws. At that time, Justice Ruth Bader Ginsburg, joined by Sotomayor, Elena Kagan, and Stephen Breyer, filed a scathing dissent. And they said that hubris is a fit word for today's demolition of the Voting Rights Act. And then Ginsburg wrote, throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet. Now, the dissent noted that discrimination today is more subtle than it has been in the past, and they cited second-generation barriers to voting that reduce the impact of minority votes. They mentioned racial gerrymandering and at-large voting instead of district-by-district voting in cities with sizable Black populations. They listed vote dilution, drawing redistricting maps in a way that minimizes voting strength of the non-white population. They mentioned curtailment of early voting, moving polling places away from predominantly Black neighborhoods, and purging voter rolls of many Black voters. After Shelby gave the green light, basically, state after state enacted and continue to enact voter suppression laws. They prevent easy access to polling places, provide for early closure of polls in Black and brown communities, make it harder to receive mail ballots, reduce early voting, restrict voter registration, and prevent the accurate counting of votes. And states such as Georgia and Texas have drawn extreme gerrymandered maps, which entrench the power of Republican politicians. Using baseless and alarmist cases of or claims about voter fraud, which is virtually non-existent, as a justification, states are passing voter identification laws that make it harder for marginalized communities to vote. And GOP-led states insert Republicans into the election process and empower state legislatures to overturn presidential election results, even after certification by election officials. This is what Trump was trying to do when he was propounding his myth of that the election had been stolen from him, and he's still propounding that myth. In 2020, the Supreme Court made it more difficult to mount legal challenges to voter suppression measures. The court held 6-3, again along ideological lines, in Brnovich versus the DNC, that 2 Arizona suppression laws, ballot harvesting and out of precinct voting, did not violate Section 2 of the Voting Rights Act, which forbids any voting procedure that results in the denial or abridgment of any right of any citizen in the United States to vote on account of race. Now, in the Shelby majority decision, they invited Congress to come up with another pre-clearance scheme that would respond to what they called current conditions. And there are 2 bills pending in Congress to address the current conditions of voter suppression. The John Lewis Voting Rights Advancement Act would establish new criteria for determining when states and political subdivisions may obtain pre-clearance before changing their voting practices. The Freedom to Vote Act cracks down on voter suppression. It would facilitate early voting, allow same-day voting and online registration, protect voters from purges, having their names purged from voting lists, in which they have been doing illegally in Georgia. Ban partisan gerrymandering, and the Democrats have agreed to this. Gerrymandering takes place on both sides, but the extreme partisan gerrymandering has been mostly by Republicans. Mandate disclosure of major campaign donors, basically going right to the heart of Citizens United. Prevent state restrictions on mail voting, require the counting of votes that are postmarked on or before Election Day, provided they arrive at polling places within a week, set uniform standards for voter identification, and provide that no one has to wait longer than 30 minutes to vote. People cannot be charged with crimes for providing food and water to people standing in line to vote, and require voter verified paper records. The House passed a voting rights bill that contained provisions of both the John Lewis Act and the Freedom to Vote Act. And on January 18th, the Democrats in the Senate started debate on the bill with a simple majority. But although there were enough votes to pass the bill with a simple majority, the Democrats also needed 50 votes to change the Senate rules to allow cutting off debate and moving to a vote, because the filibuster effectively requires 60 votes, including 10 Republicans, to advance legislation. But the Democrats didn't have a majority to change the filibuster rules because Joe Manchin and Kristen Sinema opposed overriding the filibuster for voting rights legislation with some platitudes that were hypocritical because they had both countenanced suspending the filibuster rule in the past for other measures. Now, Martin Luther King Jr. said in 1963, and think about this, he said this in 1963, that's about what, 60 years ago? Quote, "I think the tragedy is that we have a Congress with a Senate that has a minority of misguided senators who will use the filibuster to keep the majority of people from even voting. They won't let the majority senators vote." This does not bode well for voting rights in this country, and indeed for the survival of our democracy. And by the way, I should say that when this came up to a vote, there were not enough votes. They did not override the filibuster, and so the voting rights legislation went down to defeat. And so now we're going to see continued and stepped up voter suppression laws in state after state, cheating, and all bets are off about what is going to happen, first of all, in the midterm elections and then in the presidential election. I wish I didn't have such a bleak picture to paint, but I think that what this means is that we have to redouble our efforts to make sure that so many people get out to vote, especially marginalized communities, that even with all of this cheating and voter suppression, that our democracy will survive. Thank you.
Thank you, Marjorie. Very sobering, but important for us to have on the front of our minds. So we do have some questions in the question and answer, but I would like the attendees to continue to add questions. And I want to start off with a general question, which is, if either of you had been on the bipartisan commission to review the Supreme Court, would you have had any suggestions about the number, the term, or any of the rules in connection with the Supreme Court that could improve its functioning or legitimacy? You have 2 minutes to answer this question, guys. I know it's a big one.
Well, I can take a stab at it, and then maybe Glenn can as well. I think that adding members to the Supreme Court, expanding the number 9 to 13, which has been done in the past. There's nothing in the Constitution that says that there can only be 9 justices on the Supreme Court, and imposing term limits on the justices, say 18 years, would go a long way to diluting some of this politicization of the court. And FDR tried to do that. It was called court packing, because there was a 5-4 Republican or right-wing majority on the court, which was striking down all his New Deal legislation. And before they actually did expand the number of justices on the Supreme Court, that 5th swing vote changed his vote and voted to uphold the New Deal legislation. And so they didn't expand the number of justices on the Supreme Court. So it's often said that FDR won the battle but lost the war, or lost the battle but won the war, I guess you would say.
Yeah, I'll just add that I don't have new ideas that weren't considered by the commission, but I also support the 18-year non-renewable term. I think it would bring regularity and maybe diffuse partisanship. Everybody would know. And I think this is important for voters. Voters would know that when they elect a president and they choose senators, every 2 years, those people are going to be putting people on the Supreme Court. But it would hopefully eliminate some of the episodic unfairness of one president appointing a lot of people and another president not. And it would also maybe, as the commission said, prevent any one justice from having kind of a swing voter hegemony over the court, and would bring political balance to it. I'm very tempted by court packing. I think that I opposed the Kavanaugh nomination and opposed the Barrett nomination largely for procedural grounds. I didn't think we didn't even have to get into politics or ideology. To my constant embarrassment, I did not object strongly enough to the failure to consider Merrick Garland in the last year of the Obama presidency, because I knew Hillary would be elected, and she would pick somebody I would like even more. Turned out to be wrong. But my problem with court packing is it becomes, especially as Marjorie pointed out, politically, Democrats are likely not to control majorities in the future, and then so does the next group. When the president is Republican and the Senate is, do they pack the court to 16? Do I end my lifetime with a court of 37 members, which would be, I think, a disaster. So I'm very tempted. I think the political argument for court packing is very strong, but I'm concerned about the long-term implications.
Okay, our next question goes back to voting rights. So we'll go to Marjorie on this. Can you give some examples of why voter ID laws have such a disproportionate effect on people of color?
Well, many people of color and poor people don't have cars. They can't get to, they don't have driver's licenses because they don't have cars. They live in rural areas, so they can't get to places where they could get official Department of Motor Vehicle identification. And so they use other forms of identification. And what the voter ID laws do by trying to limit trying to limit what kind of ID they can use, makes it harder for these marginalized communities to vote. And I should say something that is, I guess, pretty obvious, but I think it needs to be said. And that is the reason that Republican-led states are enacting these voter suppression laws to try to keep people of color and marginalized communities from voting is that those people generally vote Democratic. So that's the reason. I don't think they're all overtly racist, although that's the effect of the laws. They ultimately are racist laws, but that I wanted to make that clear.
And you know, just some people don't have birth certificates. They don't have documents that they would use to meet the requirements here. And so there is, as Marjorie says, it's very disproportionate and unfair impact.
Thank you. So here's perhaps the question of the day, which is, what are your thoughts on the retirement of Justice Breyer and possible next Supreme Court nominee? That's for both of you.
Want to start, Glenn?
Sure. I'm gonna make a comment that will strike, a couple of comments that will strike people as very naive. I'm often the naive person in the room, but I have two thoughts. The first is, I hope before we immediately jump into all the speculation about the successor and what it means and the politics of it and all that sort of stuff, we take some time to reflect on, as your comments pointed out, Marjorie, the true positive impact that Justice Breyer has had in a number of areas on the court. Far too often we just jump to the politics of it and don't spend some time focusing on that. He truly has had a major positive impact and has written some major either majority decisions or dissents in areas that are important to me. My second point is, again, totally naive, but I hope that people on all sides of this question will give some thought, not just to short-term political advantage, but to the long-term impact of what the appointee is going to mean to the court, what a filibuster, throwing gears in the or wrenches in the gears of confirmation would do, because long past any particular president or any particular precedent, who's on the court, and not only what's their politics but what's their worldview. Can they empathize with underrepresented people and downtrodden people? Do they have life experience? Do they have some view of how some of these political effects and laws have an impact in the world? So, I have, and it's been unpopular with some of my progressive friends, said that I don't think a court dominated completely by liberals would be a good thing. I don't think a court dominated by conservatives is a good thing. I think America is overall served by a balanced court, that where you don't know the minute the court announces that they're going to hear a case, oh yeah, I know how this is going to go. And so I hope naively that there's some focus on that as well. But I'm not confident. I wouldn't bet a lot of money on it.
I understand what you're saying, Glenn, but realistically, we have had a very conservative Supreme Court, particularly on issues of race and policing, with the exception of just a few years of the Warren Court. The whole rest of the history of the Supreme Court has been enabling the police to single out people of color. And so having a court that is skewed toward liberals, I think would be a refreshing change. I don't see it in the near future, but there is no way to balance out all of that history of lopsidedness. Now, Ruth Bader Ginsburg, who was one of our great justices in so many areas, civil rights, women's rights, LGBTQ rights, workers' rights, immigrants' rights, did not step down when Obama kind of subtly suggested it during a luncheon when she had already had, I believe, 2 different kinds of cancer. She just held out to the bitter end. And it only took Trump and his right-hand man, Mitch McConnell, 30 days to get Amy Coney Barrett to replace Ruth Bader Ginsburg, which I think is one of the biggest disasters in the history of our country. If you see what what Amy Coney Barrett is already doing in all of those areas where Ruth Bader Ginsburg was so progressive, Amy Coney Barrett is on the opposite side. And so there have been calls for Stephen Breyer, who's the oldest member of the Supreme Court, I think he's 83, to step down. And he sees that Ruth Bader Ginsburg, who has a wonderful legacy, it's a bit tarnished because she refused to step down. He doesn't want his legacy to be so tarnished. And so I think that's why he's going to step down. I think it's a good move. He should have done it sooner. And Biden has said that he would appoint a Black woman to the Supreme Court. There are some very qualified, good, progressive judges that have been suggested. I think it's great that Breyer is going to step down. I wish he had done it sooner.
I agree with almost everything you said, and I'll just add that I was full-throated in my opposition to the Coney Barrett fix, which I thought really completely degraded the court and politicized, took even yet another step in the perception that the court was political.
Okay, our next question. This person says, we always talk about the partisanship of the Supreme Court majority, but are they really adhering to party or to their religious conscience? And if so, doesn't that suggest that we should have a court that represents more of the diversity of religious and non-religious beliefs that exist in our country, even if we only consider the mainstream ones?
Is it okay if I start with that? I'll just say that I think religious diversity is one of several kinds of diversity, and certainly as you pointed out, Marjorie, racial diversity and gender diversity is very important on the court. I mean, we need a court that has a range of life experiences, and by the way, I favor diversity even of background. Like that people not all be federal judges and federal circuit judges. It'd be nice if we had some people on the court that were real lawyers who had real experience in the trenches of voting rights defenses or racial justice defenses or something like that. So I think that is all very important, and religious diversity would be part of it. If this question had been asked 5 or 10 years ago, I would point out that it's not always about religion. That there, on abortion, for example, there were a number of justices who probably were Catholic but did not hew the Catholic line. It does seem that nowadays there's more of a correlation between religious views of the justice and their background. But justices bring a variety of backgrounds to the court, and we should have as much diversity as we can, given that there's an inherent limit on how many people are on the court, whether it's 9 or 13.
Yeah, I agree with Glenn, but Justice Sotomayor is Catholic. That's her background, and yet she's also got a working class background.
Yeah.
And she is the most progressive, hands down, member of the Supreme Court. And I think that I would even say when Justice Ginsburg was on the court, I would still say that Justice Sotomayor is the most progressive. And I think that it doesn't stem from her religion. I think it stems from her class background and her real, she's in touch with the people because she comes from the people, and she can really understand who the litigants are who are coming before the court. There was a time a few years ago, where every single justice on the Supreme Court, forget about the religion, had come from an Ivy League school, Harvard or Yale. And that is not very diverse either. And certainly, if they all come from Harvard or Yale or Stanford or whatever, how are they going to, as a whole, relate to real people? I'm not saying it's impossible, but I think it is a heavier lift.
Okay, here's a question. Several articles have reported that Senate votes confirming Justice Barrett were substantially influenced by lobbying efforts paid by corporate interests. Would you assume that Senate confirmation of a new justice would be biased any differently?
You mean, is that surprising?
Well, I guess it's, to what extent do you think that the questioner is correct that there was substantial lobbying around the?
I think there was. I actually have seen the research that there was. I don't remember the precise groups, but these were all so-called, not all, but largely pro-life. And when I put pro-life in quotes, I don't usually use that word. pro-life, because it's pro-birth, really, pro-birth, because after the baby is born, you know, a lot of the people who call themselves pro-life oppose medical care, education, health care. They favor the death penalty, and so I don't think it's really a pro-life position. But there was a Texas Right to Life, I think, is one of the organizations, if I'm not mistaken, that was supporting Barrett, and I believe there were a number of others as well.
Yeah, I guess the question really is about the money and lobbying interests that are behind the approval process for a new justice.
Well, if you look at, and I don't mean to you know, monopolize the
Oh, go ahead.
this, if you look at lobbying that goes on in this country all the time, every day, on every issue, senators and Congress members are lobbied all the time by big moneyed interests. You know, many of them have, you know, defense contractors who give them a lot of money for their campaigns, and so they vote for more and more money for the military, even for weapons that the Pentagon isn't even asking for. I think that the pro-Israel lobby is very strong as well, AIPAC, and many of the senators vote accordingly. And so I think that lobbying senators and Congress members is not new with Supreme Court justices, although we have this view, I think, that the justices on the Supreme Court should kind of be above money and politics. I wish that were the case, but I don't think it is.
Just to add that whether it's new or not depends on the kind of the time frame we look at, but certainly both grassroots lobbying, trying to have people, you know, contact your senator to oppose this person or support this person, or interest group lobbying has certainly continued to grow ever since the ill-fated Bork nomination, and statistics show that it has increased. So it's a really very important, it's a strong part of the process. I would expect it to kick in here as well with whoever the nominated successor is. It'll perhaps be different groups that support the nominee and different groups that oppose the nominee, but it'll be important there. And by the way, that's one of the areas where your members can make some kind of a difference by the way that they, you know, lobby their senators and the way they weigh in on it. And it is one of the few ways to, quote, lobby the court or influence the court through lobbying.
Okay, our next question. In voting rights and abortion contexts, has there been any debate regarding the broader enforcement of any state's common law public trust doctrines? In California, isn't there an affirmative obligation to preserve trust protected wherever feasible?
I'm not sure about that. Glenn, do you want to comment on that?
No, I have to say I'm not seeing the immediate connection between what the public trust doctrine is with my limited understanding of it and abortion. So sorry.
Yeah.
I think you've stumped our panel.
That's okay. Let's try another one. Do you think that more jurisdictions will enact local measures or regulations on social issues? For example, how the city of San Jose is requiring gun owners to pay an annual fee and carry liability insurance. She's wondering if this is the trend to have more local control to circumvent state or federal legislation.
I think that's a good possibility, and I actually thought that was very interesting what San Jose did, and I think we're going to see a lot more of it, particularly in light of the way the Supreme Court is heading.
Yeah, and I would add particularly the way they, in my view, fumbled twice on defending the rule of law in the SB8 cases that Marjorie talked about. I mean, if the message goes out that an individual state can, with impunity, impose damages or restrictions or whatever on what would be regarded as constitutional rights or whatever, you're gonna see more activism at the state and local level. And in the way the Supreme Court will have, bought it by its inaction and its failure to defend the rule of law, it'll end up fomenting those movements.
That's an interesting point, Glenn, because SB 8, which was crafted, as I said, to allow basically anyone, deputized anyone in the world to bring these lawsuits. If SB 8 is upheld by the Supreme Court, then people who don't like, people carrying guns, for example, could use that and bring private causes of action that could subvert so-called gun rights, etc. But I don't think the Supreme Court is going to uphold SB 8 the way it's written ultimately because of that it could be used that way. I think what they're going to do is strike down Roe v. Wade using the vehicle of the Mississippi case, the 15 weeks cutoff for abortion, and then that would circumvent the SB 8 problem, which could then be used against things like gun rights, which the right-wingers hold dear.
And I'll just mention that I sent to our leaders a link to my column on Jurist about why the court's failure on SB 8, even beyond the horrible abortion rights issues, could be problematic. So if anybody wants to check that out at no extra charge, feel free.
It's a question that is a little like the prior one, but I'm going to present it at any rate. How alarmed should we be about the federal system being eroded by state laws, like the Texas law deputizing citizens in cases far beyond the abortion case?
I think we really did kind of cover that in the.
Okay. All right. I'll go on to something else.
Can I just add that what I think we should be, how much we need to be alarmed depends on whether the court will find result-oriented and unfair ways to distinguish between SB 8 type approaches and for example, the trial balloon that Governor Newsom sent up about restricting gun rights. I mean, if the court says, states can interfere with rights we don't like, but states can interfere with rights we do, we don't need to be as alarmed. But on the other hand, that would be about as much a confession that the court is simply gonna go follow ideological divides as we could have. So I think there's downsides either way.
Yeah. Can I go with another one since Kim did too? Can you explain whether the Roberts Court's decisions that gutted the Voting Rights Act could be remedied by congressional action, if that were possible? Or have they set a new constitutional threshold that cannot be overcome by legislation?
Congress passed the Voting Rights Act in the first place, and Congress has reauthorized it several times when it comes up for reauthorization. But what the Roberts Court did in the Shelby case in 2013 was to insert itself in the process and basically usurp Congress's role by saying that we don't think that it's necessary to enforce sections 4 and 5 at this point because things are so hunky-dory now, with voting rights for minorities. So in my opinion, they did usurp Congress's role. Now, that is not to say that Congress, if we did have a Congress that could actually, get something done and was not stymied by the filibuster and people like Sinema and Manchin, could not enact a new pre-clearance formula. And that's exactly what the Shelby majority invited Congress to do, enact a new pre-clearance formula for, pre-clearing voting rights changes in jurisdictions that have a history of discrimination, enact a new formula. And that's what the John Lewis Voting Rights Advancement Act would do. Congress, and that passed the House of Representatives. And I think that, I believe that it was Manchin or Sinema who co-sponsored that bill. So it could have passed if it wasn't for their, hypocrisy on the filibuster. But Congress was poised to actually come in and remedy what the court had done in the Shelby case, but because of the filibuster mess, didn't happen.
And Marjorie, if I could just ask you, do I recall correctly that in the Bronovich case, the Arizona voting rights restrictions those were again about, those were statutory questions about what Congress's standard was. And therefore, theoretically, Congress could change the standard to be more voting rights protective. It wasn't at least technically a constitutional issue.
Right, but what, and I think Kagan pointed this out, Elena Kagan in that case, what the majority did was to come up with new criteria. They basically, took them out of whole cloth and came up with criteria that Congress had not set forth to decide whether or not voting restrictions violated Section 2 of the Voting Rights Act. And basically, they can do whatever they want. They're the Supreme Court.
Well, but my understanding is, at least in theory, they were allegedly filling in gaps that Congress hadn't clarified. And therefore, at least in theory, Congress can come along and say, we don't like your criteria. Here are the strong criteria that we want to impose.
Yes, theoretically. They could
Theoretically, and there's a looming question about whether then you could challenge it constitutionally and all that. But I was just trying to remember in my mind, because again, I know that it's nice to at least, the standard question people have when you tell them how bad things are, and as we have to do in our profession, is what can I do about it? Should I just be resigned or whatever? But it's nice to know at least that in theory, League of Women Voters members and officials who are concerned about voting rights could actually lobby for laws or try to get people passed who will break the filibuster, or at least it may be hard, the gradient may be high, but at least that's a possibility.
Right.
Is it my turn?
Yeah.
Okay, this is for Glenn. What is your opinion of how the Supreme Court majority views Americans who are members of groups that appear to be disfavored by Republicans? Persons of color who are not members of the elite, persons in need, persons whose sexuality or sexual orientation are different from what has been traditionally acceptable in mainstream America?
Rather broad question, but I would say in general, there's too many examples where in print and in opinions and all that, at least, I won't paint them all with the same brush, but at least some of the Republican appointees, some of the ones that are the most conservative, show a shocking disregard or cluelessness when it comes to understanding those kind of rights. I mean, it's not across the board. You get the occasional Justice Kavanaugh writing an opinion that talks about how brave transgender people are. Of course, he doesn't vote for them in interpreting Title VII, but you get some kind of language about that. But I would say in general, it's part of a broader critique that justices don't seem to, partly because of the way they're confirmed and all that, don't seem to have a lot of empathy and a lot of willingness to recognize that maybe there's different kinds of Americans. I suppose the other side would say, well, the Democrat liberals don't understand what it's right to run a business and deal with, those kinds of issues. So, I mean, I'm sure there's some of that on both sides, but that is one of the things that I hope we will focus on with Stephen Breyer's replacement, is finding someone who is even more able to empathize, especially on police rights and all that, with minorities.
Yeah. I feel like we have given you a marathon to run and you're still running it. We're nearing the end here. I do have a quick question for you, which is, are you concerned about what is known as the shadow document? Is this sort of a way to get around transparency? Is there any way to oversee it? Any comments on that?
I think you're talking about the shadow docket, and that
did I say that wrong? Yeah, docket.
Yeah, I think that's what you're talking about. The shadow docket, which the Supreme Court's been using increasingly to make decisions kind of in the shadows without full briefing, oral argument, lower court decisions that go up through the process. And they've been making some very, monumental decisions that way. And there's been a lot of criticism. The SB 8 case is an example of that. And there's been a lot of criticism of that. The problem is, you have the whole issue of recusal. If a justice has a conflict of interest, should he or she recuse themselves and not sit on a case? There's no one above the Supreme Court to police them. Congress could, this is my understanding, and maybe Glenn would disagree, Congress could pass laws and trying to regulate how the court runs its business. And I think that the court would say, hey, we're the Supreme Court, and there's nothing you can do about that. But yes, there has been a lot of criticism of that so-called shadow docket.
I think you had 3 questions. Yes, I'm concerned about it. I forgot what the second question was, but the answer was yes. And can we deal with it? It really depends. As Marjorie said, there may be limits to what Congress can do. But I think there's a process. It's a bit like court packing. When the court feels more pressure, it may put up a brave front, but it sometimes tends to try to cut back on its sails a little bit to kind of clean up its own act. And I would think, from what I'm hearing and from what the several of the justices who are trying to defend themselves are saying, I think they're going to get more of a realization that the shadow docket is difficult. I think you saw it imply is problematic, and they should try to limit it a little bit. Again, as Marjorie says, they're the ultimate probably determinants. I don't know how if I were assigned to write a bill that says, okay, you shall use the shadow docket in these legitimate reasons, but not in these illegitimate reasons. It would be hard to write that. But I think you may get some cutting back. There were some recognitions, for example, when they held hearings on SB 8 the second time around, rather than just do it based on the shadow docket. That was kind of an implied confession that they had rushed to judgment before. When they expedited concern over vaccines, they had 2.5, I believe it is, hours of oral argument. So I think there's kind of a recognition, and they'll probably try to cut back their sales a little bit, but it is a problem. Transparency is always better, as I think it was Holmes said, sunlight is the best disinfectant. And so we should be focusing on that and supporting some of the proposals in the Biden commission to deal with that.
The Congress has had bills such as the Sunshine in the Courtroom bill to try to get Supreme Court arguments televised. I actually wrote a book about this, to get them televised. And Justice Souter said, the day a camera comes into the Supreme Court, it'll roll over my dead body. Now, he's not on the court anymore. It used to be that we didn't even get to hear in real time the audio part of the oral arguments, and now we can hear those. But Congress can pass laws until it's blue in the face about requiring cameras in the Supreme Court, and the court is not going to allow it. And I think that that's another example of this. But I agree with Glenn. They are, as much as they're in an ivory tower, they do understand what public criticism means, and which may affect their behavior. But I don't think Congress has a lot of power over the way they run the court.
Thank you.
Really
it is
interesting
3:30, and
discussion.
I think we do need to stop and let you go take a break. But thank you so much. I definitely will be getting your slides, Glenn. We so appreciate your great thoughts and energy and insight for this important subject. So
Thanks to both of you, and thank you to Jane and Sheila for making this happen.
Yeah, and great to work with you, Marjorie.
Yes, I really enjoyed it, Glenn, and I'm going to get a copy of your slides as well.
Okay, good. They'll have come to some value then. All right.
yeah. We do have a survey for people to fill out, which will come which you'll see on your screen. So please fill it out. We appreciate that.